Welcome back, law school students and curious minds, to another Explainer. Today we're diving deep into the fascinating world of contract law, specifically Chapter 5, Defenses to Formation. I actually like to think of this as the contract escape artist's playbook. Why? Because we're basically looking at the legal trapdoors that let a party completely escape an otherwise validly formed contract. You've got your offer, your acceptance, your consideration, the whole shebang looks totally perfect on paper, but what if there's a hidden flaw? Well, let's find out.
Okay, let's map out our journey today. We'll cover when apparent agreements fail, deception and hidden truths, pressure and unfair terms, capacity and public policy, and we'll wrap it all up with a battle-tested bar exam attack plan.
Section 1. When apparent agreements fail. Right out of the gate, we absolutely have to nail down the difference between a void contract and a voidable one. This is crucial. A void contract is just a complete nullity from day one. Think of a contract to, say, commit a crime. The court treats it like it literally never existed. But a voidable contract? That one is actually valid and legally binding right up until the protected party decides to pull the ripcord and disaffirm it. It's entirely a choice.
Now, what about misunderstandings? This happens when parties attach materially different meanings to the exact same term in a contract, and neither of them has a clue about the mix-up. We see this perfectly in the classic 1864 case, Raffles v. Winchell House. The parties agreed to trade cotton arriving on a ship named Peerless sailing from Mumbai. The catch? There were actually two ships named Peerless sailing months apart. The buyer was thinking of the October ship, the seller was banking on the December ship. Because they meant two entirely different things, there was no mutual assent, no meeting of the minds, no contract, period.
Let's contrast a mutual mistake with a unilateral mistake. A mistake is basically an erroneous belief about a fact that exists at the exact time the contract is made. If both parties share that wrong belief, boom, mutual mistake. But if only one party is wrong, that's a unilateral mistake. And let me tell you, getting out of a contract for a unilateral mistake is significantly harder. The mistaken party usually has to prove that enforcing the deal would be brutally unconscionable, or that the other party actually knew about the error and was trying to take advantage of it. You literally cannot study contract law without meeting one of the most famous animals in legal history, Rose 2D of Aberloan from the Sherwood v. Walker case. Sherwood bought Rose for $80 because both he and the seller, Walker, were absolutely certain she was a barren cow, useful only for beef. But surprise! Right before delivery, Walker discovered Rose was pregnant, which made her a highly valuable breeder worth up to $1,000. The court ruled this contract was voidable. Why? Because the mistake wasn't just about the cow's quality. It went to the very nature of the thing. The fundamental substance of the bargain was completely altered.
Section 2. Deception and hidden truths.
So, to successfully claim misrepresentation and escape a contract, you can't just be a little bit misled. You need a false assertion of a past or existing fact. That assertion has to be material, meaning it would influence a reasonable person, or it has to be outright fraudulent. And crucially, you must have justifiably relied on that lie when entering the contract. Also, keep in mind, active concealment, like hiding a major defect, totally counts as a false assertion.
Usually a salesperson hyping something up, puffery, isn't considered a fact, so it can't be misrepresentation. But the Vokes versus Arthur Murray case, it is a brilliant exception. Audrey Vokes, a 51-year-old widow, was flattered into buying over $31,000 worth of dance lessons. That was a massive sum at the time. The instructors kept telling her she had incredible potential, even though she genuinely didn't. The court said that because the dance studio had vastly superior knowledge and exploded a relationship of trust, their opinions crossed the line and became actionable misrepresentations of fact.
Section 3. Pressure and unfair terms. All right, this brings us to duress. Physical duress is obvious. If someone literally forces your hand to sign something, that contract is completely void. But economic duress? That's where things get interesting. This happens when someone makes an improper threat to your financial interests, leaving you with absolutely no reasonable alternative but to sign, making the contract voidable. A perfect example is the Austin Instrument case, where a subcontractor threatened to withhold vital Navy radar parts unless the prime contractor agreed to huge price hikes. Facing severe penalties and having zero other suppliers, the prime contractor signed. The court rightly called that out as economic duress.
Undue influence is a whole different beast. Unlike the outright threats we see in duress, undue influence is really about over-persuasion. The Odorizzi case is the textbook example here. an elementary school teacher, was arrested, aggressively questioned for 40 hours, and was just severely exhausted. Immediately after he was released, his superintendent and principal showed up at his apartment pressuring him to resign right then and there to avoid public humiliation. The court found undue influence. The teacher had an undue susceptibility due to sheer exhaustion, and the officials applied excessive pressure by exploiting that weakness at an incredibly inappropriate time and place. Now for the ultimate safety valve for courts, unconscionability. If a contract is just shockingly unfair, a court can just refuse to enforce it. But you usually have to prove two things here. First, procedural unconscionability, which means shady unfairness in the bargaining process itself. Think gross inequality of bargaining power or burying terms in microscopic boilerplate fine print. Second, substantive unconscionability, meaning the actual terms of the contract are commercially unreasonable and depressively one-sided. Courts use a sliding scale for this. A ton of procedural unfairness means you might need a little less substantive unfairness to void the deal, and vice versa. And that brings us to the absence of meaningful choice. Judge J. Skelly Wright coined this incredibly powerful phrase in the landmark case Williams v. Walker Thomas Furniture Company. Miss Williams, a highly vulnerable consumer, bought furniture on an installment plan. The store used a really complex cross-collateral clause buried in the fine print. Basically, it meant that until she paid off every single item she ever bought from them, the store kept the title to all of it. When she defaulted on one tiny payment, they tried to repossess everything. The court stepped in, citing that profound absence of meaningful choice.
Section 4. Capacity and Public Policy.
The law fundamentally recognizes that a valid contract requires informed consent. Because of that, it protects specific classes of people who are deemed to lack the legal capacity to fully understand what they're actually agreeing to. If a person lacks capacity, the contracts they enter into are generally voidable at their option.
This breakdown is an absolute goldmine for your outlines, so feel free to pause and take notes. Minors can avoid contracts, but they are still liable for the reasonable value of necessities like food and shelter. For mental incapacity, pay close attention to the modern volitional test. Even if someone cognitively understands a contract, if a mental illness prevents them from controlling their conduct, the contract might be voidable. And intoxication? Just having a few drinks isn't enough. You have to be so intoxicated you literally don't understand your actions, and the other party has to actually know you are that incapacitated. And then we hit the absolute brick wall, illegality and public policy. The courts are simply not going to help you enforce an agreement that violates the law or harms the public good. If you sign a contract to commit a tort or a crime, it's totally void. But it goes beyond just crimes. If a non-compete agreement is wildly unreasonable in its geographic scope or how long it lasts, a court might strike it right down for violating public policy. When contracts cross this line, the court typically just washes its hands and leaves the parties exactly where it found them.
Section 5. Bar Exam Attack Plan. Okay, let's turn all this theory into actual points on your exams. When you're staring down a brutal, complicated fact pattern on the bar, march through these 6 steps sequentially. Don't just jump straight to the conclusion. First, spot the potential defenses. Then, carefully state the specific legal rule, like those exact elements of misrepresentation we covered. Apply the facts meticulously to those elements. Critically, make sure you conclude whether the contract is void or voidable. And step 5 is huge. Always look for overlapping defenses. A vulnerable person pressured into a terrible deal could trigger undue influence, misrepresentation, and unconscionability all at the exact same time.
So what does this all mean? Ultimately, all of these defenses ask one massive, fundamental question. Where do we draw the line between our freedom to contract and the necessity of fairness and genuine consent? It's a really delicate balance the law is constantly trying to strike. As you ponder how the law balances free will against exploitation, please be sure to like this explainer and subscribe to our Law Office Study channel to master even more essential legal frameworks. Thanks for joining us, and keep learning.